Rules of conduct. The rules of conduct that I am about to discuss are binding upon all CFP professionals. They are vital for establishing and maintaining a high professional standard. Because the world of financial planning is so diverse, you may well find that some of the rules described here don't apply to your particular sphere of influence. That being said, you must take care to ascertain which rules do apply to you, and then do your very best to keep them. If a CFP professional violates these rules, he may be subject to discipline and could possibly lose the right to use the CFP trademark. Now, these rules, however, are not designed to be a legal basis for liability to any third party. Rule 1. Defining the relationship with a prospective or existing client. To fulfill the role of a financial planner properly, the nature of your relationship with your client needs to be clearly defined. So the first rule within the rules of conduct is, the CFP certificant and prospective or existing client should mutually agree upon the services to be provided by the certificant. For a financial planner to build a successful relationship with his clients, the following issues need to be discussed early in the relationship. The obligations and responsibilities of each party under the agreement with respect to. Defining goals, needs, and objectives. Gathering and providing appropriate data. Examining the result of the current course of action without any changes being made. The formulation of any recommended actions. Implementation of responsibilities, meaning who should do what. Monitoring responsibilities, meaning who will keep an eye on what. Other important issues for the professional planner to consider are, number 1, the issue of compensation. This includes the factors and terms that determine the cost, how these decisions benefit the CFP professional, and in which way. Number 2, the terms of the contract that would allow the CFP professional to offer his client proprietary products. Proprietary products are additional services that his company exclusively provides and may not be available elsewhere. Number 3, the conditions under which the CFP professional might use other entities to fulfill the terms of the agreement. This may include the use of a money manager or consultation with an accountant or tax professional. You should encourage your clients to read all written information carefully and recommend that they ask questions. Always answer your clients' inquiries openly, honestly, and clearly. After you have clarified and agreed upon terms with your client, you must put them all down in a written agreement between the CFP certificant or his employer and the client. This agreement should include the following points: the parties involved, the date and duration of the agreement, how and under what terms it can be terminated, the specific services that will be provided. This agreement can consist of a number of written documents used by the CFP certificant or his or her employer, as long as these forms include the conditions given above and comply with federal or state regulations and conform to the rules of a self-regulatory body. This is acceptable. The first rule, defining your relationship with the client, should always conclude with putting your client's interest ahead of your own. Remember that your role is to implement the needs of your client, and his benefit should always be paramount. In fact, a CFP certificant always owes it to his client to provide the care of a fiduciary as defined by the CFP board. Rule 2. Information disclosed to prospective and existing clients. You should always endeavor to be upfront with your clients and provide them with accurate information. The facts you give must be correct and should not either directly or indirectly mislead the listener with regard to your qualifications or the services that you provide. Never confuse anyone about the potential benefits of these services. Always be sure to disclose all relevant information that is necessary so that your clients do not have misunderstandings. As a CFP professional, you should give prospective and existing clients the following information: a current and accurate description of your compensation arrangements. This should include your cost and compensation, the terms under which you or your employer can receive compensation from other sources, and the sources of such payments. A summary of any likely conflicts of interest between you and your client or other third parties. For example, if your employer happens to be your mother or you work closely with your uncle's company as a legal affiliate, you must disclose this family connection. The same applies to any contractual or agency relationship that could have a material effect upon your connection with your client. You need to disclose any information about you and or your employer that might materially affect the client's decision to use your services. For example, if your prospective client is divorced and you happen to be currently working with the ex-spouse, you would be expected to disclose this information. only after getting approval from the ex-spouse to divulge his or her name. You obviously must also give your contact information, and where applicable, that of your employer. As above all, this information should be in writing and can consist of several documents. This documentation is acceptable if it contains all of the information listed here and complies with state or federal law or the criteria of a self-regulatory body, such as the Securities and Exchange Commission's Form ADV. All disclosure documents must satisfy the requirements of this rule. It is of prime importance that whenever the aforementioned information changes, you should inform your client as soon as possible. Rule number 3. Prospective and existing client information and property. Complete confidentiality of information is a very important CFP rule. All client information has to remain absolutely confidential. Although this rule is extremely important, there are some exceptions to it. Confidential information may be supplied if it is needed in response to a proper legal process or to fulfill an obligation to the certificant's partner or employer. It can also be disclosed if necessary to defend against charges of wrongdoing in connection with a civil dispute, or to expedite the proper execution of the CFP professional services. Nonetheless, to ensure confidentiality of information, you must take every necessary step to protect the security of any stored data, whether electronically or physically. So you're probably asking at this point, exactly what information are we talking about here? First of all, this relates to every piece of information that is necessary for fulfilling your obligations. All of this information must be gathered, and if anything is lacking, you must inform your client of all material deficiencies. Secondly, you need to identify the specific assets over which you will take custody, exercise investment discretion, or have supervision. Keep comprehensive and complete records of all the client's assets and property that have been placed in your custody or under your discretionary authority. At this point, we should also mention the famous Shakespearean quote, "Neither a borrower nor a lender be." Rule 3 includes the requirement that a CFP certificant should never borrow money from his client. This would be a major breach of professionalism that could seriously damage their working relationship. The only exceptions to this rule are 1. If the client is a member of the certificant's immediate family, and 2. If the client works for an institution that lends money and the loan is unrelated to the professional service being provided. It should also be said that all of the above also applies to a reverse situation. A client should not borrow money from a CFP professional unless the situation is one of the exceptions mentioned above. Another important rule regarding property is that the CFP professional should never combine his client's property with his own or with that of his employer, unless this is permitted by law or specifically written in an agreement between the two of them. The same applies to commingling one client's property with that of another. This is also explicitly prohibited unless there is a specific written authorization from each client and you keep proper track of whose assets are where. Another important point to remember is that you should always return a client's property to him upon his request as soon as you can, or within the specific time frame given in a written agreement between the two of you. These clear borders must always be maintained throughout your working relationship. Rule 4. Your obligations to your prospective and existing clients. You must always provide your clients and prospective clients with a professional service and understand their needs. Integrity and objectivity should be your watchwords. This includes providing clear and objective advice to your clients. However, you should only offer advice where and when you are competent to do so, and consistently maintain your level of competence in all areas of your professional life. Essentially, this means that you should not try to bluff your clients by advising them on subjects that you know very little about. It is better to be upfront and say that you don't know enough about the issue to give concrete advice. If that is the case, in addition, you should always be looking to increase your existing knowledge and ability in order to maintain your level of competence. If at any point you need to assign responsibility for any of your services to a third party, you must always provide capable and prudent supervision over that party's activities. And if for any reason your certificate from the CFP board is either revoked or suspended, you have a responsibility to inform your clients of that fact. Rule 5. Your obligations to your employers. As an employee, you also have obligations to your employer. These are 1. To follow your employer's or firm's lawful objectives, and 2. To follow the CFP Board Code of Ethics. Just as your client needs to be aware of your status, it is your obligation to also inform your employer if your CFP certificate is either revoked or suspended. Rule 6. Your obligations to the CFP Board. Your obligations to the CFP Board are pretty straightforward. You need to follow all of its requirements for using its trademark, and you must cooperate fully with its regulations, including maintaining the standards of practice mentioned in the Code of Ethics. To continue using the CFP trademark, you need to follow CFP's continuing education requirements. If your contact information, such as your email address, business or home address, or telephone numbers change, you need to notify the CFP Board within 30 days. If you are convicted of any crime aside from traffic offenses, unless the misdemeanor involved alcohol or drugs, you are given any professional, discipline, or bar. It is your duty to inform the CFP Board within 10 days. Needless to say, a CFP certificant should not engage in any behavior or pastime that would reflect negatively on his or her integrity as a certificant or upon the CFP Board or the profession in general.